and the Constitution has provisions that address how a sitting president can be removed from office. And that's the difficulty that, as federal judges of limited jurisdiction, we have to abide by.
Your Honor, first, if Mr. Obama is not a natural-born citizen, if he's not a citizen, then he never was elected president because he could not qualify to be president. Therefore,
that's an issue that would be identified or dealt with by the Congress or arguably perhaps the Attorney General.
Well, my point is, Your Honor, he could not be impeached. Unless you have a sitting president, you can't impeach him, number one. Number two, it was the argument of the Department of Justice, which Judge Carter seemed to bite on, that it was up to the Electoral College or the Congress to deal with this issue. The problem with that, as we argued in our brief, Your Honor, opening and reply, is that number one, 26 states in the District of Columbia have laws which mandate criminal or civil penalties for electors that do not vote in accordance with the majority or plurality wishes of the voters in that state or district. So they have no discretion to challenge. And under 3 U.S.C. 15, which the DOJ argued, that provides for challenges raised by Congress to the paperwork of the electors, whether they were properly selected, whether the paperwork was properly submitted by the courts. There's no provision in 3 U.S.C. 15 for any dealing with eligibility. There's no provision for anybody dealing with the Electoral College. So the only recourse to the people is the courts. Otherwise, the second, Article 2 requirements for the president are unenforceable and therefore meaningless. And that is a result that, to me, shreds the concept of our Republican form of government. We have to have, the people have to have a way to challenge somebody when the powers that be, the majority parties in this case, the Democrats and Republicans, say, we don't care about the AIP or the Libertarians or the Natural Law Party or whoever it is. You know, they're unimportant, only we count. And so we're not going to do anything about it because maybe next time it'll be a Republican who's not eligible. John McCain was the subject of lawsuits over his eligibility. Congress held hearings on whether John McCain was eligible, was a natural-born citizen eligible to run. And they actually made a finding. In fact, their finding actually helps any case we have because their finding says you have, essentially implies you have to have two American-born citizens as parents before you can be a natural-born citizen run. But that's not before the court. But I mean, this has all been done in the last couple of years, but nobody's willing to take on Mr. Obama. Nobody's willing to ask the hard questions of him. John McCain, it's okay. Not Mr. Obama.
How did the McCain hearings come about?
The people in the Democratic Party initiated hearings. They were the majority party in the Senate, and they initiated hearings and held hearings. And Senator McCain, retained counsel Lawrence Tribe and Ted Olson, if I remember correctly, and they submitted legal briefs, and the matter was voted on. And a finding was made that he was a natural-born citizen and eligible to run. The question being over his birth in Panama.
Yes, I know. I recall that. The question that I have then is, have you sought to initiate that kind of process?
Through Congress?
Yes.
We don't have the right to do that, Your Honor. Only members of Congress have the right to do that.
You don't have a right to petition Congress?
Well, we could petition them, but only a member of Congress has the right to request those.
So you're saying that congressional members brought the McCain issue on their own? Nobody pressed them to do that?
I don't know, Your Honor. The more important thing is the ruling by Congress was, in essence, non-binding. Well, it didn't have the weight of any law.
Okay.
Your Honors, unless you have more questions, I'd like to reserve my time for rebuttal, if I may.
All right.
Thank you, Your Honors.
It says here time remaining 2:41. How do I reset it? I'm sorry. It says here time remaining 2:41. I'm supposed to have 10 minutes.
Start the clock again. Each side gets 10 minutes.
No, 20.
No, it's 6:52. I need 10 minutes.
10 minutes. No, each lawyer, we have two lawyers. Each gets 10 minutes.
Start the clock when you start talking.
Okay.
Okay.
I'm ready.
1, 2, 3, go.
Good morning again. I'm Orly TAITZ. I'm representing Ambassador Alan Keyes, who actually has unique standing because he ran against Mr. Obama twice. He ran against him for Senate in 2004. There were 2 finalists in the senatorial run. And if indeed Mr. Obama, as the evidence shows, committed fraud, and the evidence that we have shows that he does not have a valid social security number. He is using a number that was never signed, does not have a valid original birth certificate, what he recently provided to the public, and I believe greatly influenced the country as a whole, and might possibly, possibly even somehow influence the courts with all the future proceedings by publishing this computer image claiming that to be a true and correct copy of his original birth certificate issued in 1961. And analysis shows that it's not a true and correct image of original birth certificate. It's a very inventive computer art, where bits and pieces were taken from different documents, put together, and this image was created. Not only Mr. Obama has done that, he created this psychological Kristallnacht against people who are bringing these kind of legal actions to court. He called us carnival barkers, and that started mass hysteria in the media, saying we need to go away, get out of the country, and so forth. Of course, Ambassador Keys has perfect standing because if indeed fraud was committed and Mr. Obama does not have proper papers, he could never become not only the president, he could never become the senator from the state of Illinois, and Ambassador Keys and President Obama were the finalists in that competition in 2004. Additionally, my clients are members of U.S. military. And I'm sure your honors know that just recently, a fellow member of U.S. military, Lieutenant Colonel Lakin, was imprisoned when he was supposed to redeploy to Afghanistan, and he was asked for his birth certificate. He stated, why should I show and not Mr. Obama? He said, I will be willing to go if I know that I have a legitimate commander-in-chief. And he was denied his right to fair trial. The presiding judge, and I was at that trial, stated that he cannot bring the issue of eligibility, and he is today rotting in prison. This high-ranking officer is sitting in prison in Fort Leavenworth. He lost his pension. So my clients, and there are 30 of them, some of them are here, who are members of U.S. military, are greatly concerned that all the evidence show Mr. Obama not being eligible, him not having a valid selective service document, not having valid social security number, not having valid birth certificate, not having valid educational records, sitting in the White House, and if they're questioning him, they will be sitting in prison in Fort Leavenworth, just as Lieutenant Lakin is sitting there. Lastly, my clients are 10 state representatives from different states. As you know, Your Honors, there are a number of issues that are currently being heard in different states. Among them, the health care reform. The states have balanced budget amendments, and they need to know whether indeed when they are trying to implement different measures or executive orders coming from the White House, they want to know that those orders are legitimate when they are implementing those orders in their states. Additionally, this case is different from all the other cases, and the beauty of it, the standing, as a matter of fact, doesn't even count. Why so? Because I filed this case on inauguration day, before Mr. Obama did anything as U.S. president. Mr. Obama never filed an answer. And we had a default hearing on July the 13th of 2009. Now, if Mr. Obama were to file an answer, and he would have stated, well, there is a problem with standing of those plaintiffs, we would have been arguing standing. However, he didn't, in spite of the fact that he was served 4 times. During the motion hearing that I asked for on the issue of default, Mr. Obama could not send his own attorney or U.S. attorney on his behalf, because then it would have shown that indeed he was served. So what he did, he sent this gentleman, assistant U.S. attorney, and it was a trick. They said, well, he is here, but he is not representing the president, he is representing the United States of America. And pressured the judge and me to serve Mr. Obama for the 5th time, yet again, through him. And I refused, I flatly refused to do it. And Judge Carter stated on the record, well, if you refuse, this case will be dismissed. I'm inclined to dismiss it. It's going to be sitting in the Ninth Circuit for a year, and you owe it to the country to have this case heard on the merits. I refused again. I said, Your Honor, we're losing our due process and constitutional rights. You can either give me the default judgment or deny it. You cannot pressure me and under duress make me serve Mr. Obama for the 5th time through the U.S. Attorney's Office. That's undue influence. And the hearing lasted, I think, over 2 hours, and repeatedly Judge Carter kept pressuring me. And here there is a violation of due process and First Amendment right for redress of grievances, because I was pressured under duress to serve Mr. Obama yet again. And this particular instance was an instance of the court exceeding the court's judicial discretion, abusing the judicial discretion. Additionally, this U.S. attorney had no standing to be there to begin with. He was not representing the plaintiffs. He claimed he is not representing the defendant, so he had no standing to argue anything and be part of the case to begin with. And there was an abuse of judicial discretion on part of Judge Carter to go ahead and demand that I serve U.S. attorneys who were not part of the case. They were not representing anybody in this case. Additionally, as that was done, Judge Carter made sort of a quid pro quo, a deal. He stated, if you serve the government the way they want, he didn't even say that I didn't serve Mr. Obama correctly. I served him correctly under Rule 4E. And the U.S. attorney provided an incorrect reconstruction of the statute. He stated that I did not serve him correctly, that I had to serve him under Rule 4I, as 4I, and I correctly stated, 4I is reserved only to governmental officials that are being served in regards to something that they're performing within their duties. I'm serving him in regards to fraud that he committed before he became the president. It was not done as part of his duties. It was done for his own benefit. So, and I'm seeking also an order stating that there was improper reconstruction of the statute. There was an error by Judge Carter, and due to this error, the case needs to be overturned. The decision needs to be overturned. And there was a clear pattern of undue influence on this federal judge by the U.S. Attorney's Office, or actually by the White House, using this U.S. Attorney's Office, and additionally using his own private attorney, one of his private attorneys, who was placed to work as the clerk for the presiding judge. That was an outrage. It was a clear lack of impartiality, because a Perkins Coie attorney, Sidharth Velamoor, was placed as a clerk for this judge, writing an opinion for the judge. I mean, I came from the Soviet Union. I would expect this in the Soviet Union, but I would not expect it here. Additionally, Judge Carter read some letters that came to him, to his chambers, and in his final ruling, he quoted those letters that were highly defamatory about me, the plaintiff's attorney. I filed motions for reconsideration, and I repeatedly demanded to have access to those letters and have a hearing to provide my side of the story. I was defamed, my livelihood was affected, my position with the state bar was affected, because the judge included in his order letters that were sent to him directly to his chambers, and I had no opportunity to even see them or respond. clear lack of impartiality, abuse of judicial discretion, and for all of those reasons, and I'm running out of time, this case has to be, the decision needs to be overturned, and I should get my right for default judgment and post-judgment discovery of the documents that I am seeking. I did bring, I don't know if the court would be willing to give me more time, I gave more information.
Thank you very much.
I have 10 seconds.
Yeah.